do we have any union employers here at all? Okay. Which is about the percentage of, I mean, the American workplace is about 7% collectively bargained, so it's about consistent with where we are nationwide. For those of you that are non-union, you might be thinking, well, I don't have union employees. Why do I even care what the NLRB has to say about anything, since we don't have a contract with a union? And the answer is because the NLRB, I think, recognizing that they only touch 7% of the American workforce, has, over the course of the last several years, made a huge power grab for the other 93% that really help keep themselves relevant as an agency that matters for the majority of American workers. And one of the areas that the NLRB has done this is in the area of what it's called protected concerted activity. I'm going to give you the big kind of 40,000-foot view of what this means. Employees under the National Labor Relations Act have the right to, whether they're in a union or not, between or among themselves, talk about wages, hours, benefits, and other terms and conditions of employment. And employers cannot retaliate against, discipline, fire employees who talk between themselves about these workplace issues, and can't have policies that unreasonably restrict employees' right to do so. So where we typically see this is employees who talk about wages, for example, to say they can't be retaliated against under the National Labor Relations Act. You can't have, I see it in a lot of handbooks I review where companies have policies that say, it is against company policy for employees to disclose how much they earn, and if they do, they can be subject to discipline up to and including termination. Big no-no under the National Labor Relations Act. But the NLRB has gotten much more nuanced in how they're attacking this issue. And I just want to give you two real-world examples from two real-world NLRB cases. One case involved a employee who took to his personal Facebook page to vent about how his manager was treating him and his coworkers. And this is what he wrote on his personal Facebook page, and I'm going to self-censor to try to stay PG. He wrote, quote, "Bob is such a nasty mother effer, don't know how to talk to people, F his mother and his entire effing family," and then doing his best Donald Trump impersonation, concluded with, "What a loser." Company fired him, and unfortunately for the company, "What a loser" wasn't the last thing that Bob wrote on his Facebook post. He actually concluded his post with, "and please vote yes for the union," because his company was involved in a union organizing campaign. The employee was fired and then went and filed a charge with the NLRB saying, "I was fired for voicing my opinion about how these employees should vote for the union." The employer said, "No, we fired you. We don't really care what you said about the union. We fired you because you used this horrible, obscene language talking not just about the manager, but like his family and his wife and what have you." The NLRB said, "Mr. Employer, you tolerate your employees." There was testimony that the employees use obscenities in the workplace all the time, so we think you're not nearly as sensitive as you say you are. And because this employee concluded his Facebook post with, "and please vote yes for the union," we conclude that that's why you fired the employee, and we find that you violated the National Labor Relations Act for restricting this employee's right to engage in protected concerted activity. I think there's a big distinction between employees who on a shop floor throw F-bombs across at each other and an employee who goes either to a supervisor's face or on Facebook uses obscene comments to essentially threaten a manager. The NLRB, however, disagreed. And the NLRB has gotten even more nuanced in another case involving a sports bar where the employee not just went on Facebook, or it was an ex-employee who went on Facebook to complain that the company owed this employee money, and then two former coworkers, current employees, who were Facebook friends with this employee, didn't do a thing other than click the like button to this former employee's post about how this company owed him money. And the NLRB said the mere act of an employee clicking the like button on Facebook is protected concerted activity. So you can see how nuanced the NLRB, how far the NLRB is going to reach workplace speech to regulate what employers can and particularly can't do when employees talk about work, particularly talk about work online. And the NLRB has gone even further to not just regulate firings or discipline when they actually occur, but to dig into what employers' handbooks say. The NLRB has published 2 separate memos, one specifically dealing with social media, and more recently, one dealing with employee handbooks across the board, detailing policies that are unlawfully restrictive, in the NLRB's opinion, on employees' rights to engage in this protected concerted activity, and those policies that are legal. And the NLRB is drawing really, really nuanced distinctions. So, for example, the NLRB says the following is illegal. Be respectful to the company, other employees, customers, partners, and competitors. That's an illegal policy in a handbook. Be respectful to the world. Illegal because the NLRB says, even though there is no union organizing campaign going on now, if we hypothetically assume maybe in the future one could occur, union organizing campaigns might become nasty and contentious, and an employee might, down the road, maybe possibly read that be respectful policy as somehow infringing on their right to maybe be not respectful during a union organizing campaign. That's how far the NLRB spins this to conclude that a policy that says be respectful to everybody is unlawful under the National Labor Relations Act. The NLRB says the following policy, however, is legal. No rudeness or unprofessional behavior towards a customer or anyone in contact with the company. That's okay because that policy specifically targets third parties, doesn't mention employees or coworkers, and therefore it's not going to bring these union issues into play. Give you one more example. Unlawful policy. Employees are prohibited from wearing cell phones, making personal calls, or viewing or sending texts while on duty. Unlawful. Lawful, no cameras are to be allowed in the store or parking lot without the prior approval from the corporate office. Really, really fine, narrow distinctions the NLRB is drawing between a policy that one could potentially assume maybe might impact an organizing campaign if it happens, versus a policy that the NLRB says one can't. I commend to your reading. You can find it on the NLRB's website. You can find it on my employment law blog, the Ohio Employers Law blog as well. If you go back through the NLRB archives, these policy memos that the NLRB Office of General Counsel has published, and it's scary. And if you have not reviewed your employer, if you've not reviewed your employee handbook as recent as in the last 6 or 12 months, in light of what the NLRB is doing in this area, you really, really, really should. The ambush election rules, the NLRB has published new regulations, new interpretations that have really, really sped up union organizing campaigns. And it's not just shortening the time frame between when a union comes in to organize and when an election is held, but it's also things like requiring when a union has files an organizing petition, requiring the employer to provide to the union the email address of every employee that is potentially in the bargaining unit. And one thing that unions are doing as a result, unions only need a 30% showing to get an election. Historically, unions won't file petitions unless they're well above 50% because they want to file and know they're going to win. With these new rules in place where unions now can get things like employee email addresses, unions are filing with 30% because they're then getting those contact lists, so they can then start sending email information, reaching out electronically to employees, withdrawing the petitions, and then using that contact information to aggressively target and pursue employees to get out their propaganda for why employees should support the union, and then refile at a later date when they have much stronger showing once they get their campaign fully in effect. As a result, non-union employers need to be much, much more proactive in how they approach unions and the potential of unions in the workplace. Once a union organizing petition is filed, it's frankly too late because the election is going to be held as quickly as 10 days after, and you just don't have the time as an employer to run the effective campaign that we would like to run to tell your employees why unions are not a good idea. what I recommend is what I call the team approach to union avoidance. It's train, educate, affirm the open door, and modernize policies. You train your supervisors. They're your first line of defense in terms of what to look for when a union is coming in. You train them. You educate your employees before a union petition is even filed as to why unions are not a good idea and won't work for your business. You affirm the open door so that employees have somewhere to go to complain to management about issues. But if you read the studies, they will tell you that money and benefits are not the reason why employees organize. It's because they feel they don't have a voice with management. If you give them a voice by not just having an open door policy, but having it really work in practice, so that employees are comfortable going to management, going to their supervisors, going to HR, going to the CEO or president of the company to talk about issues that come up in the workplace, much less likely that a union, if that communication is there, much less likely that a union will be able to get a foothold if they come in. And then modernize your policies. Take a look at your handbook. Get a union statement in your handbook. Take a look at your no solicitation policy to make sure that your employees understand when it is okay for them to engage in non-work related solicitations in the workplace and when it is not. One area where solicitations has changed, however, is in the area of email communications. Used to be under the Bush II NLRB, there was a decision called Register Guard, which said that it was okay for employers to prohibit employees from using the workplace, the corporate email system for union-related business. It was okay to have a policy that said, and you can't use our company email system to engage in union-related activities. Just earlier this year, that all changed under the Obama NLRB. A decision by the name of Purple Communications came out, which said it is actually now illegal under the National Labor Relations Act for employers to have a policy or to restrict employees who otherwise have access to a corporate email system, to restrict them from using that email system for union business. So if you have employees that use your corporate email system for work-related business, you can no longer have a policy that restricts them from using that email system to engage in union-related activities. Your system has to be open to union-related activities. You can shut off access to employees altogether. You can say only exempt employees can use our email system, and there's no reason for non-exempt employees or potential union members, people that could potentially join a union, non-supervisors, to use our email system. But if you allow access, you absolutely have to allow that access for union-related business as well as work-related business. The last issue I want to talk about before we open it up to questions deals with joint employers. This decision just came out in the last several weeks. The NLRB last year announced that it was going to be pursuing unfair labor practice charges against McDonald's, the McDonald's Corporation, on behalf of unfair labor practices and collective bargaining efforts, organizing efforts that were going on, not at McDonald's Corporation, but at franchisee-owned McDonald's restaurants. So the NLRB took the position, at least from we are going to charge the conduct as unlawful, that they were looking to hold McDonald's Corporation, the franchisor, liable for unfair labor practices committed against non-employees of the franchisor employed by the franchisees. Just 2 weeks ago, a decision came down against Browning Ferris, a staffing agency, where the NLRB said, we are holding the staffing agency liable for the unfair labor practices of the companies to whom it places employees. Under a theory of joint employment. The NLRB said the staffing company is a joint employer of the employer to whom it places the employees, just as it is alleging that McDonald's franchisor is a joint employer of the franchisee. And in issuing this decision, the NLRB made a key change in its own joint employer standard. What the NLRB says, it used to be that in order for two entities to be joint employers under the National Labor Relations Act, there had to be some amount of actual control. We have all these arm's length corporate business relationships, franchisor, franchisee, contractor, subcontractor, staffing agency, placing organization. All these arm-length transactions where the company sitting on top, the franchisor, the contractor, the staffing agency, has no control over what goes on in the workplace at all. All the control sits with the franchisee, with the subcontractor, what have you, with its employees. The NLRB said that actual control doesn't matter anymore. All that matters is that there exists some potential for some exercise of control to happen, period. And if that potential exists in any way whatsoever, we are going to hold that you are joint employers. And so as a result, staffing agency, you are a joint employer. The McDonald's case hasn't come down yet, but I would expect when it does, the NLRB is going to say, McDonald's, franchisor, you are McDonald's Corporation, you are, as the franchisor, a joint employer with your franchisees. And so think about the potential, the mind-numbing implications of holding a franchisor, for example, liable for unfair labor practices or collective bargaining obligations to employees that it does not employ, has no say over their hiring, their firing, their discipline, or what have you. And it doesn't stop with the NLRB. Both the EEOC and OSHA have already said, guess what, we're looking at the same issue. We're looking to hold franchisors, staffing companies, contractors liable as joint employers for safety violations of their subs, for discrimination committed by their subs. It is a scary, scary, scary proposition for an employer, for a company to think we can be liable for something over which we have absolutely no control just because some federal agency is going to come in and look and think of a possibility of control that one could possibly exercise.